Michael Arnold here again, and Bernard the Barrister Bear. And this time, I want to talk about costs, and particularly about costs of litigation, costs of going to court. And I did touch upon this in the video on footballers' wives, but I want to deal with it specifically on its own. In that particular case, as I mentioned, the Vardy and Rooney case, the costs that the losing party had to pay were estimated at £1.5 million. £1.5 million. That's for lawyers' costs. Now, defamation cases, of which that was one, do tend to be very expensive, but this is a general problem in English law as a whole, not just defamation. The general rule, sometimes referred to as the English rule, is that in a court case, in a lawsuit, the loser pays the winner's costs, of course, in addition to their own. The loser pays the winner's costs. But this is one of the very few jurisdictions where you can go to court over a dispute over, let's say, £100,000, and you can lose the shirt off your back as a result of that. There are other jurisdictions, there are other countries where the loser has to pay the winner's costs, but it's not as dangerous as it is here. Now, I have very often to advise clients who have an arguable case if they want to go to court, and I have to say to them, look, your chances are just perhaps barely more than 50-50. Don't take it to court, because if you lose, you could lose your house quite easily. There are certain types of cases, particularly personal injury cases, where you can now get no win, no fee, but there is very often a problem in the small print. No win, no fee, and if you do win, then what? Then the fees kick in, of course. And it's not as straightforward as it seems. It's not as easy to get as you might think either, because obviously no law firm is going to take on no win, no fee if they really don't expect to win at all. If they have no prospect of winning, that's not going to happen. There are different types of insurance you can take out as well, but in general, going to court is still a very high-risk strategy in this country. Maybe you'd say, well, maybe that's a good thing, because it will discourage unnecessary litigation. Well, possibly, but it also discourages a lot of very meritorious litigation. And the trouble is that the law, especially the law of tort, being in a state of disarray, as even Lord Neuberger put it, and without reliable principle, lacking reliable principle, this means that it's very difficult to predict the outcome of a case in advance. And also, actually, makes it more likely that the case will go on appeal. Because if you lose at one level, because the law is so uncertain, why not try the next level and the one above that if you are given permission to do so? But certainly 2 levels. You will need permission to appeal, but if you have a sufficiently strong case, you should get that permission. But the thing is, why do we not adopt the practices of other countries which likewise have a system of the loser paying the winner's costs, but keep it within bounds? Like, for example, Germany. The German system is really, I think, excellent, because, yes, it also works on the basis of the loser paying the winner's costs, but it never gets out of hand. You're not going to lose your house going to court in Germany, even for quite a large amount of money, if the dispute is about a large amount of money even. It works on inverse proportion, which I think makes good sense. In other words, the lower the value of the claim, the higher the percentage of that claim that can be claimed by lawyers, that can be charged by lawyers, because lawyers' fees are all based on a statutory, yes, statutory system which is carefully calculated and is based on the value of the claim. Statutory, that means it's been passed by Parliament, or the German, in Germany's case, the German equivalent of our Parliament. The Bundestag, German Bundestag, and the Bundesrat, 2 houses of the German legislature. It's not left up to the individual lawyers to decide, nor is it left up to the courts, but it is statutory. Yes, it is possible for lawyers to ask for more than the statutory amount from their own client, but that has to be specifically agreed with the client. And then if that client wins a case, then he still has to pay that amount. And he cannot claim the extra amount above the statutory amount. He cannot claim that from the other side. He has to pay that himself. So that's the only slight wrinkle on that system. But otherwise, it is, as I say, in inverse proportion. So the very lowest claim, let's take a claim of, say, 500 euros, the lawyer can only charge 45 euros. on a €500 claim. That's 9%. It's a very small amount, €45, but it's a high percentage. And as you go up the scale in terms of the value of the claim, so you go down the scale in terms of percentage of that claim that can be charged by a lawyer. And at the very top level, it used to be around 2%, actually now more like 1.5%. But if one works it out at 2%, over €500,000, 2% is the maximum that a German lawyer can charge for his work on a case worth that much. Why is it done this way? Why is it done in inverse proportion? Well, for a very good reason, because there is a certain basic amount of work involved in even the lowest claim. So that's got to be factored in. But as the value of the claim increases, the amount of work involved does not increase pari passu, does not increase proportionally with that. It doesn't. There's a certain basic amount of work involved in any case. But the value of the claim doesn't really escalate the amount of work. So therefore, it makes sense to have an inversely proportional system of costs, lawyers' fees. Why can't we introduce something like that here? Really, it's about time something was done. There was an attempt, much was made of it a few years ago, to reform the whole costs regime, but all it did was to make some fairly minor changes. It did make some changes, yes, it did introduce some good changes, but the essential problem remains, which is that it's left to the lawyers essentially to charge more or less whatever they like. And the trouble is, we have this two-profession system here, solicitors and barristers, which of course adds to the costs tremendously, and no proper controls. Solicitors, in particular, don't have to give you an itemized bill. I'm reading now from the website of the Law Society, which is the solicitors' professional organization. They themselves actually say here, if your case went to court, your solicitor may give you only a summary bill, sometimes called a gross sum bill. You can ask your solicitor for a detailed breakdown, but you need to ask for it within 3 months of getting the summary. The detailed bill will replace the original summary bill. If your solicitor is suing you for an unpaid bill, they don't have to give you a detailed version. So even if they are suing you for not paying, they don't have to give you a detailed version. That makes no sense. Makes no sense at all. And if the courts are not involved, if it's a non-contentious type of case, your solicitor will give you a summary bill, sometimes called a gross sum bill, summary, just summary. You can ask your solicitor for a more detailed bill, but they do not have to provide one. Why not? surely that's the most basic right, to get a detailed breakdown of your bill. But that's a serious problem. More next time.